Good evening and welcome to the Brothers and Sisters podcast. I believe this is episode number 5, but don't quote me on that. We got an exciting show tonight. Today is February 10th, Thursday, February 10th, 2021, and we're recording from Baltimore, Maryland. Of course, Walter is coming from Delaware, and our esteemed guest tonight, Dr. Katherine Marshall Woods, is coming from Washington, D.C. She's going to kind of sort of be our guru, our Sherpa through mental health, and particularly its connection to media, in a conversation that's going to be led by Autumn. But first, as it is Black History Month, we're going to continue with sort of my Black History legal case study, case theory. Last week, we focused on Dred Scott and basically the elimination of Black personhood in 1857. In fact, even being bothered to question whether Black people were people in 1857 was deemed to be a deprivation of due process rights for white slave owners. So take that for what you will. We're now 26 years later, post Reconstruction and into the 1880s, where we have our next major case in the path towards civil rights and equality for Black people, which would be simply known as the civil rights cases of 1883. To give you some background, the civil rights post the last major piece of legislation before the end of Reconstruction, which of course is 1876. And for those of you who don't know what Reconstruction is, just briefly, it was a set of programs and policies aimed by the federal government to ease Black people back into, or not even back into, introduce Black people into citizenship, into American citizenship post-Civil War. And the jump that really started during the Civil War, but you really say the impetus would be the Reconstruction Amendments, the 13th Amendment, which abolished slavery, the 14th Amendment, which guaranteed equal rights to all, and then the 15th Amendment, which promised voting rights for Black men. Those were the three Reconstruction Amendments. And now we're post-Reconstruction in 1883. At the very end of Reconstruction, which again ended in 1876, the Civil Rights Act of 1875 was passed, which basically said that you couldn't discriminate by race in public accommodation, public transports, theaters, any place that the public used. With the language highlighted in the 14th Amendment, basically stating, no state shall make or enforce any law which shall abridge the privileges and immunities of citizens of the United States, nor shall any state deprive any person of life, liberty, or property without due process of law, nor deny to any person within its jurisdiction the equal protection of the laws. So that's the 14th Amendment. That's basically what equal protection is. That in order to make this stick, the federal government had to give specific places, specific examples of where this would not apply. And that's where the suits came in. Business owners at that time, proprietors of restaurants, movie theaters, public places, etc., were basically saying it's their constitutional right to be racist. Like that's in a private transactions, you can be as racist as you want to be. That was basically the opposing argument. And the basis of the legal question being, does the Civil Rights Act of 1875, the major piece of legislation coming out of Reconstruction, violate the 10th Amendment? Which, again, the 10th Amendment in the Constitution says that if it's not explicitly outlined, if a law is not explicitly outlined or mentioned in the Constitution, then the power goes to the states. So in other words, if the Constitution doesn't say you can't be racist or you can't deny me service because of my race, then it's a state decision and state laws are out. And the court ruled, being that this is 1883 in the United States of America, the Civil Rights Act did violate the 10th Amendment. Private acts of racial discrimination are private wrongs that the national government is powerless to correct by means of civil rights legislation. We all know that the federal government would correct this wrong by means of federal civil rights legislation, it would just take 80 more years, right? This is 1883, 1968, 85 years, right? And it was 8-1. What can we draw from this? Dred Scott established that Black people were not people, and then it took a civil war to kind of sort of codify the principle that we were people in the law. The civil rights cases show the fight that we would have, that we still have in some respect, in some regards today, about what it means to be protected as historically disadvantaged and marginalized people within the federal government. This case basically said there would be no protection, and of course was a precursor for state governments establishing what we now have come to know as Jim Crow laws, which would be challenged in the case I go over next week. With that being said, that's all I have today. Sorry about the long-winded legalese, a long-winded history lesson, but it's something that's very important to me, and I think it's ideal that we understand how we got here today in 2021 from 1619. And legally, as we established last week, it wasn't even, legal rights for Black people weren't even a thing until, well, it wasn't even questioned until Dred Scott, and the answer was no, you have no legal rights. So that's where we are. Anybody have any comments or questions or anything like that? No?
Not much has changed. Laws are in place, but people are still resistant.
Mm-hmm. We have a lot of the outright de jure, like kind of sort of this law's in the books that I can discriminate against you. That stuff is almost gone. Well, that was the point of the civil rights movement, right? To eliminate that. Now we just have a lot of de facto stuff, a lot of, well, we know we can't discriminate against you, but if we establish a homeowners association that allows only certain types of people to live in their neighborhood, that's not, that's not de jure discrimination, but we all know what the impact is, what the effect is. And that's why, we talked about redlining last week. I think Lindsay brought it up when I made my claim that Baltimore was the least racist city. And we still didn't get an answer for that. No one can tell you. Is it Austin, Texas? That's what we said now.
And I don't know what it's like to live there.
I've been to Austin a couple
times. It's very racist. I lived there in 8th grade, 6th grade, 7th grade. It's racist.
It's the state capital of Texas. Take that what it will.
So Kwaisi, your argument is Baltimore is the least racist city. Do you mean over time or this
over time? And remember, I started with this.
That makes more sense because
with this foundation of
right now, Baltimore's the least racist city. It's
yeah, not now. I would have no determination of what the least racist. Like I said, we'd have to come up with some criteria and a test, a metric to first determine how you quantify racism in cities, and then actually apply it, right? But if there isn't anything else on the civil rights cases, I want to get to tonight's main course, if you will. First, so let me stop.